Thanks, everyone. I declare open this hearing of the Select Committee on Administration of Sports Grants. We acknowledge the traditional owners of the land on which we meet and pay our respects to elders past, present and emerging. These are public proceedings and a Hansard transcript is being made. The hearing is also being broadcast via the internet. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as contempt. It is also contempt to give false or misleading evidence to a committee. The committee prefers all evidence to be given in public, although the committee may determine or agree to a request to have evidence heard in private session. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer is given in camera. Such a request may also be made at any other time. The committee understands that all witnesses appearing today have been provided with information regarding parliamentary privilege and the protection of witnesses. Additional copies of this information can be obtained from the Secretariat. Finally, I ask everyone to check their mobile phones to ensure they are either switched off or turned to silent. I will just ask in request to the media representatives who have sought permission to film or take photographs. I would like to advise that representatives of the media have requested permission to film and take photographs of the committee's proceedings, and the committee has agreed to this. I remind the media that this permission may be revoked at any time, and the media must follow the direction of Secretariat staff. If a witness objects to being filmed or photographed, the committee will consider this request. The media are reminded that they are not able to take images of senators or witness documents or of the audience. Media activity may not occur during suspensions or after the adjournment of proceedings. Copies of Senate Resolution 3 concerning the broadcast of committee proceedings are available from the Secretariat. All right. So the commencement of this session, I welcome the Auditor-General for Australia and other representatives from the Australian National Audit Office. Thank you for appearing before the committee today. Before we begin, could I ask each of you to please state your name and the capacity in which you appear for the benefit of the Hansard transcript.
Grant Hare, Auditor-General.
Rona Mellor, Deputy Auditor-General.
Lisa Rowder, Group Executive Director, Performance Audit Services Group.
Brian Boyd, Executive Director, Performance Audit Services Group.
Amy Wilmot, Senior Director, Performance Audit Services Group.
Thank you. I now invite you to make a brief opening statement, should you wish to do so, and after that I will invite committee members to ask questions.
Thank you. Good afternoon, Chair and committee members. Thank you for the opportunity to appear before the committee today as part of your inquiry. Grants administration is an important activity for Commonwealth entities involving payment of billions of dollars of public funds each year. The ANAO undertakes a number of grants audits each year, and findings from audits reveal that grants administration is on a continuum from good to poor. We commenced this audit in March 2019, and the ANAO invested more than 3,800 hours of effort over a period of 10 months obtaining and analysing evidence and in the development of the report that was tabled on 15 January 2020. The audit was conducted in accordance with the auditing standards, which require that sufficient and appropriate evidence be obtained to address the audit's objectives and support the audit's findings and conclusions. We concluded that the award of grant funding under the Community Sports Infrastructure Program was not informed by an appropriate assessment process and sound advice. The decision to undertake the audit followed a request from the Shadow Attorney-General, the Honourable Mark Dreyfus, QC MP, for an audit into the circumstances surrounding the Liberal candidate for Mayo's presentation of a cheque to the Yankalilla Bowling Club for a project that received $127,373 in funding for the second round. The key rationale for undertaking the audit was that, unlike previous grants audits, Sports Australia as a corporate Commonwealth entity is not subject to the Commonwealth grant rules and guidelines when administering its grant program. The objective of the audit was to assess whether the award of funding under the Sports Grants Program was informed by an appropriate assessment process and sound advice. To form a conclusion against this objective, we followed the following high level criteria. Was the program well designed? Were applications assessed in accordance with the program guidelines? Were the funding decisions informed by clear advice and consistent with the program guidelines? For many years, the ANO has been auditing the award of grant funding. Our methodology is well developed. We examine the award of funding against the relevant government framework, which, for most entities, is the legal framework governing spending of public money, the Public Governance Performance and Accountability Act, supported by the Commonwealth Grant Rules and Guidelines, and guidelines specific to the program. For this audit, the PGPA Act and the Australian Sports Commission Act provided the overarching legal framework against which we audited. Although not subject to the Commonwealth Grant Rules and Guidelines, consistent with better practice, Sport Australia had in place a documented grant management framework that is based on the Commonwealth Grant Rules and Guidelines. There was also published program guidelines that had been approved by the Minister, which outlined the application, assessment, decision-making processes that potential applicants and other stakeholders were informed would be adopted. A positive aspect of the program design was that the program guidelines were well structured and included clear assessment criteria with transparent weightings. Overall, we concluded that the design of the program was deficient in a number of important areas, including greater analysis was needed of the likely demand for grant funding and the strategies developed for the managing of high-level demand, strategies to manage risk to the quality of the assessment process set out in the Sports Australia Grant Management Framework were not implemented, and conflict of interest management arrangements were not to a consistently high standard. A further significant shortcoming was that while the program guidelines identified that the Minister for Sport would approve the grants, and despite both the Department of Health and Sport Australia identifying doubts about the Minister's legal authority, there are no records evidencing that the Minister was advised of the legal basis on which the Minister could undertake an approval role, and it is not evident to the ANAO what the legal authority was. Sports Australia's assessment of applications was largely in accordance with the published program guidelines. Sports Australia assessed each application for eligibility and against the 3 merit criteria to arrive at an overall assessment score. Scores against the 3 merit criteria were used to rank the applications, but Sports Australia did so within the 3 funding streams, which was not consistent with the program guidelines. In parallel, the Minister's Office had commenced its own assessment process to identify which applications should be awarded funding. This process drew upon considerations other than those in the assessment criteria, such as the project's location, including coalition, marginal electorates and targeted electorates, and also applied considerations that were inconsistent with the published guidelines. It was this assessment process that predominantly informed the Minister's funding decisions rather than the Sports Australia process. Funding decisions for each of the 3 rounds were not informed by clear advice and were not consistent with the program guidelines. Key departures were as follows. Board-endorsed recommendations existed for the first round but were not provided to the Minister because the Minister's Office had used criteria that were not published and before the panel had met, had informed Sports Australia which applications would be approved. Sports Australia's subsequent written brief to the Minister did not reflect the board-endorsed recommendations. For the second and third rounds, Sports Australia used the results of the assessment work that the panel had supported and the board had endorsed, but the assessment panel and the Sport Australia board did not otherwise play a role in deciding which applications should be recommended in either the second or the third round. For the second round, Sports Australia's written briefing reflected those projects the Minister's Office had told it would be approved, rather than the results of merit assessment work the board had endorsed. Reasons for funding decisions were not clearly documented. There was evidence of distribution bias in the award of grant funding. Overall, statistics indicate that the award of funding was consistent with the population of eligible applications received by state and territory, but was not consistent with the assessed merit of applications. The award of funding reflected the approach documented by the Minister's Office of focusing on marginal electorates held by the coalition as well as those electorates held by other parties or independents members that were to be targeted by the coalition at the 2019 election. The report made four recommendations. The first three were to Sports Australia and addressed program design, management of conflicts of interest and records of assessment work. Sport Australia agreed to each recommendation. The fourth recommendation was made to the Australian Government about extending the advising, decision-making and reporting requirements of the Commonwealth grant rules and guidelines applying to situations where a minister approves grant funding for a program being delivered by a corporate Commonwealth entity. The Department of Finance noted the recommendation and advised that it would brief the Government on the ANO's findings and recommendation. The audit also included some key messages for all Australian government entities, including Sport Australia. These messages included that it is poor practice for entities to be instructed what their advice should recommend rather than providing their own recommendations that are developed through an evidence-based approach, and potential applicants and other stakeholders have a right to expect that program funding decisions will be made in a manner and on a basis consistent with published program guidelines. We'd be happy to answer any questions from the committee.
Thanks, Mr Hare.
Chair, can I just, is that possibly a copy of that statement? Have you got, could that be tabled? Just be helpful. Questions? It looked like you had a written statement there, Mr.
Yeah, it
is that possible to be tabled to the committee so we could all have a copy? They could, if they could copy it.
I'm sorry.
Thank you.
Thank you.
Thanks, Mr Hare. I'll hand to Senator Farrell.
Thank you, Chair. And before handing over to my colleague, Senator Gallagher, who's very forensic, just like to thank you for coming along today. Thank the media for the interest that they've shown in this issue, and to indicate that we very much appreciate the work that you've done on behalf of the Australian public in this respect, and particularly thank Mr Boyd and Ms Wilmot for their role in all of this. Just to be sort of clear about a few issues, I think you said, Mr Hare, that this started with the novelty check in the seat of Mayo from the former candidate there, Miss Georgina Downer. Is that where the process started?
We received correspondence from, as I said, the Honourable Mark Dreyfus MP requesting that we undertake an audit flowing from that. My decision to undertake an audit, when I looked at his request, my decision to undertake an audit was more based on the fact that when we looked at the grant program, it was a program being delivered by a corporate Commonwealth entity, and that wasn't something we'd done for some time, particularly in the context of corporate government entities not being subject to the Commonwealth grant rules and guidelines. So that was the interest that we had in the program.
Yeah. Now, I think you said you started the process in March last year. I just want to be clear about how long that took. I know the report was handed down in early January. Was the whole of that period, so let's say 9 months, was that the time that you...
It was 10 months. Under
10 months, okay.
my legislation, I'm required to table the report as soon as practical after it's completed, and that's what we did.
Right. So the whole process from way to go took a period of 10 months.
Yeah. So an average audit for us takes about 9 months. This was a little bit longer.
Took a little bit longer. Well, the Christmas period did intervene, I guess. Did that have a material effect?
Not really.
Not really?
No.
Okay. All right.
That's only a week, really.
Okay.
Sorry? Auditors don't have
No,
holidays.
they work around the clock. Can I hand over to my friend?
Thank you, Chair. I'd like to start on page 12 of your audit, where you note that your audit, as is expected, was provided to Sports Australia, the Minister, but also an advisor, and to the Department of Health, the Department of Finance, again as expected, and an advisor from the Prime Minister's office. The Prime Minister has said his office didn't have anything to do with the Community Sport Infrastructure Program on a number of times, that he'd just passed on representation. So I guess my first question to you is, why did an advisor to the Prime Minister, receive a copy of your proposed report or extracts of the proposed report prior to its tabling?
If you look at page 39, footnote 46, we mentioned there
Yep.
a comment with respect to the Prime Minister's office. It's pretty standard practice for us when we do that as a matter of natural justice, to give people an opportunity to see what we're publishing.
That footnote says that representations were received across both rounds, all three rounds, both directly and indirectly, and that you saw evidence of that, including through the Prime Minister's office. So the audit draws particular attention to the Prime Minister's office.
So we gave an individual that page of the audit.
And which advisor received the report? Just roll, if that's the more appropriate way of dealing with this.
I don't recall the name, I recall the name.
Can I just say that the tradition has been that
I'm not asking
we
for
do
a
not
name.
gratuitously
No, I'm not.
troll individual names
Well,
through the
no.
Hansard.
Senator Abetz, it's named in the report. I'm asking for the role. I'm not necessarily asking for the name. I'm not seeking that information.
Can we take that on notice?
Okay. Did you speak to this advisor during the course of the audit?
No.
So they weren't formally interviewed?
No.
Did you seek any documents from the advisor, from the office or from the Prime Minister's department?
No.
And on what date was the proposed report provided to this advisor?
If you just bear with me for a second, Senator.
Yep.
The 14th of November, which was the date that the Section 19 was issued to all recipients.
Section 19, on the 14th of November.
Yes.
That's the draft report, or extracts from it are issued for a period of 28 days.
Okay. Was the, and you said you gave them, was that page 39 was provided to them?
I can tell you exactly which paragraphs if you bear with me for a second.
Thank you.
In terms of what we took on notice, the job title was Senior Advisor, and the relevant extract provided is what's paragraph 3.20 in the audit report,
Yeah.
was what was provided along with what's now footnotes 45 and 46 in the audit report.
Okay. On footnote 46, it says the evidence available to the ANAO. Could you explain that a bit further? What was that? What form did that evidence take?
So principally emails.
Yeah.
So part of the process, if you look at the audit methodology as described in the audit report, was, and it's fairly standard for us, is we obtained email records which showed the process by which the assessment process was conducted, as well as the decision making, since a lot of government businesses transacted through emails. So that included emails which were going into and out of the Minister's office, who were the key people involved in that parallel assessment process and the decision-making process. And so that included the emails that were going back and forth between the Minister's office and the Prime Minister's office.
Okay. And over a specific period of time?
The period of time in terms of that, so there were 3 funding rounds.
Yep.
So the period of time in terms of that engagement lasted from the middle of October until the middle of April, in terms of that's when the, if you like, the decision-making process was taking place as to which applications would be approved in each of the 3 rounds. So obviously we've looked at each of the rounds as well as overall, but essentially that sort of interaction, if I put it that way, was between the middle of October and the middle of April 2019. So October 2018 to April 2019.
So that's emails going back and forward that you saw as part of, or that you received as part of the audit?
Correct.
Okay. Was the advisor, under your certificate was it the Section 19 request? Were the advisor able to discuss the contents of what they had, of what you'd made available, that paragraph, with anybody?
No.
No. Was the advisor able to provide comment to you or
That's
feedback?
the reason we provide Section 19. It's
Yeah.
when we get to the end of an audit, we provide a copy of it to anyone involved in the process to make sure that they have an opportunity to comment back on on their views of what we've said, and then we're required to include that in the report.
Yeah.
It also gives us a final check on accuracy. So sometimes people will come back and say, well, you've got this wrong, and we try and get it as accurate as possible. So it does the two purposes of in giving us a final assurance over the evidence, and also an opportunity for natural justice to people to say, well, that's not what happened, this happened, those type of things.
Okay. Well, and was any comment provided? I couldn't
No.
find any. No.
No, we're required under the
Yeah.
Act to publish any comments that are provided.
Yeah, I thought so. In terms of, again, going back, you're saying that there was evidence of emails going back and forwards around the assessment of eligible applications and decision-making between a period of some 6 months. How many emails would you have seen as part of the evidence that you gathered?
No. In terms of precise number, I couldn't tell you. I mean, comfortably dozens. I mean, the role was as things developed. So in mid-October, the minister started requesting that the size of the program be increased from the $30 million. So that's when the engagement essentially started, with engagement through the Prime Minister's office saying we'd like to seek to increase the size of the program. Then, as we moved through the various rounds, things we saw were things such as we mentioned in the audit report, the spreadsheets in terms of identifying which ones might be approved, and there isn't a single spreadsheet. There's dozens of versions of a spreadsheet, and for each round there were various iterations indicating on different days and sometimes different hours of the day which of the projects which the Minister's office were indicating were going to be approved for funding. And some of those iterations were shared through the Minister's offices, and then there was also, as we mentioned in the report, the direct and indirect representations, which is either simply passing on where a Member of Parliament has said, we'd like these projects in my electorate to be approved, or the Prime Minister's office involved in indicating these are the ones we think should be included in the list of approved projects.
So in the process, the evidence that you got were email, so the spreadsheet going back and forth over a period of time, but also consider the inclusion of other applications for the sports grants as well. What should be considered was, it's sort of a conversational.
Can I just make clear here? We didn't do an audit of the representations going on. We were auditing the decision-making process. So while there was many representations coming into the Minister's office about the grant funding program, our interest was on the decision-making process for the allocation of funding. And the reason we didn't go into the representation process was that I didn't feel that it was material to the decision-making process. That is, as you'd expect when a grant program's going, people would like to get a grant in their electorate funded. For us to see that there was bias or some driver in that, we'd have to identify in those representations that there was a correlation between what the representations were and the outcome. And that we didn't see that type of correlation, so we didn't do a detailed audit of representations.
No, not for the purpose of the audit. I guess for the purposes of our job to understand how decisions were being made, I think.
No, the limits of what we can say is what we audited. That's all I say that for.
Absolutely. All right. So can you tell me how many emails went back and forward between the PMO and the Minister's office?
We'd have to take that on notice.
Rightio. Okay, well,
To clarify...
I'm not seeking the emails or anything, just the number over that period of time that you've nominated, a 6-month period of time. And also, was it the Minister's office or the Prime Minister's office that initiated the discussion about increasing the size of the program that you mentioned?
It was the Minister and her office.
Right, okay.
That's what the evidence says to us, and that's what's in the audit report.
In terms of, sorry, I'm probably running out of my time. But in terms of the Minister's involvement, again, I've got some similar questions. It notes that it was provided to the Minister's office and to advisors within that. Were they singled out for a particular reason, the advisors that you, in the Minister's office, that you name on, or you don't name, but you identify on page 12?
So part of
two key advisors.
Yes. So the auditing process involves us going through the records and speaking to the entity that's responsible for the program, looking at how the assessment work was conducted, how the decision making was undertaken and so forth. And those records and discussions with Sport Australia people indicated to us and was confirmed to us that the then Chief of Staff and the relevant senior advisor in the Minister's office were the two people who were most directly involved in that process of deciding which grant applications would be awarded funding in each round.
Yeah.
And so that's the process we went through in terms of identifying these are the two key people. And obviously when we interviewed those people, we asked them about their role, which also meant that if there are other people that we weren't aware of that we needed to speak to, they could identify that to us in that process.
Okay. So you formally interviewed these advisors?
Correct.
And did you seek any documents from these advisors?
We didn't seek. The then Chief of Staff showed us documents in the course of his interview, which one of those is included as an appendix to the audit report.
Were they still working for the government when the proposed report was provided to them?
The Chief of Staff was then a former Chief of Staff, so was no longer employed.
Okay. And did they provide any comment back once they'd seen
the then Chief of Staff rang us to discuss what he saw as editorial comments, but no formal comments, and we didn't receive a response from the other advisor.
Okay. Did you change your report based on these comments?
I recall there was a footnote or a rogue letter which was a spelling mistake which we corrected, but other than that, no.
So it wasn't of substance?
No.
The changes weren't of substance?
We had it was a telephone discussion with myself. We had a discussion about with some of his comments whether we would consider them to be editorials rather than comments of substance, and I indicated some of his other comments we would consider comments of substance, not editorials. Therefore, we wouldn't make a correction as in, so one was clear, the one that we made was clear, it was a spelling error in what he gave us, so we corrected the spelling error. The others would have substantively changed what had been tendered to us, so that's the opportunity, as the Auditor General mentioned through the Section 19 process, to offer those formal comments which can then be reflected.
Okay, so you got some formal comments back?
No.
Right, just the phone conversation?
Just the phone call.
And an agreement to disagree, was it?
That's
It's
probably
relatively normal at that stage for us to get... Entities usually give us three things when we give it out. They'll give us a formal short response, which is in the front of the report, a detailed response, which is in the back of the report, including their response to recommendations, and then they'll give us a number of issues that they think we should correct or change. Then we'll work through that and see whether the changes they want are supported by evidence, and then I'll make a decision whether the changes are made or not. That's what I talked about earlier, the normal process of getting assurance that the report is accurate.
Okay. All right. Were those comments provided, I think you said, from the 14th of November, so they have 28 days, so it was within that window, was it?
It was.
Okay. Just in terms of, sorry, Chair, before I hand over, the footnote 46, where you say there was direct and indirect representations, what do you mean by that? What does that mean specifically?
So the indirect representations, that's referring, for example, where Prime Minister's office simply passing on, if you like, an email or advice of a conversation had with a member of Parliament or their staff or a candidate as to these are ones we'd like to see favourably considered in the process. I'll put it that way.
That the member of Parliament would like to see.
Yeah.
Indeed. And the direct representations were more that direct involvement in terms of, when getting iterations of the spreadsheets, suggestions directly about these ones rather than those ones, or passing on lists of applications as to whether they could be included and those to be approved.
Okay. So when I read that footnote, I'm also reading that it's members of Parliament beyond the Prime Minister's office. Is that right? So the indirect, where you say indirect, it could cover a member of Parliament just forwarding saying, I know this application's gone in, I'd really like you to consider it. That would classify as indirect?
Yeah, given to the Prime Minister's office, who then forwards it on to the Minister. Or
So it all goes, it's all contact through the Prime Minister's
indirect
office?
is largely a reference to things that are coming through another party. If a member of Parliament, we'd say if a member of Parliament did a representation on behalf of a body in their electorate, that'd be direct. That's sort of the classification.
So there were some other members of Parliament directly engaging with the Minister's office saying, these are the ones I'd like to see approved in my electorate.
Right. So in terms of the emails, the evidence that you say of email evidence, particularly going between the Prime Minister's office and the Minister's office, did that also occur with other members of Parliament, the spreadsheet being shared with other?
The only evidence we saw of the spreadsheet being shared was between the Minister's office and the Prime Minister's office, not with any other members of Parliament or any other Minister's offices.
Right, okay. Is my time up, Chair?
Thanks, Senator Gallagher. Senator Russ.
Thank you. Thanks, Mr Hare and the others there. Look, so your audit is looking at, it's an audit of the administration of the grants project. So it's looking at clearly Sports Australia, but also how it's being administered by the Minister's office.
We're looking at the process for the award of funding, and as the Minister was the decision maker in the process, then it goes from Sport Australia through to the Ministers and their officers' activity in it.
And so your conclusions where you say that Sports Australia's assessment of application was largely in accordance with the published program guidelines, but then in parallel, the Minister's office had commenced its own assessment process to identify which applications should be awarded funding. The Minister's office drew upon considerations other than those identified in the program guidelines, such as the location of projects, and also applied considerations that were inconsistent with the published guidelines. So it was this assessment process that predominantly informed the Minister's funding decisions rather than Sport Australia's process. This resulted in the assessment process to the Minister being inconsistent with the approved funding guidelines. So in your assessment of the process, this parallel process that was going on within the Minister's office, can you take us through what you could ascertain to be what were the criteria that the Minister's office was using in that parallel process?
Probably not, Senator. That was one of the challenges for us. It was clearly evident that it wasn't the assessment against the published merit criteria through the published assessment process that was being relied upon. You'll see it in the audit report. We reference other factors which, both in terms of what was documented at the time, but also what the then Chief of Staff told us in terms of criteria that were being applied, which is in that appendix in the audit report, were being applied instead. We couldn't actually see, because the evidence from both the Chief of Staff and the former and the advisor was both that they didn't make records as to how they applied those. We attempted to see whether we could apply them. So we mentioned some of the considerations. One, for example, was the evidence to us was that if a project had obtained some money towards it from elsewhere, we wouldn't include them in those to be approved. And the problem for us was twofold. In that example was some of the projects approved had obtained money elsewhere and yet were still approved. And equally, the program guidelines had actually said that obtaining co-funding was something which would be favourably considered, not penalised, so that was at odds with the guidelines. But we couldn't see, for any of the applications approved, what was recorded as to why this one was being approved in lieu of the assessment as per the published program guidelines. The only thing we could see was there was a documented approach saying that there was going to be priority given to projects located in a marginal and target electorate, and we could see through the records of the decision-making process that that was something which was clearly identified in those. There was no identification, for example, of these other considerations as to how they were being taken into account, but we could see those were being recorded, and we could see through the analysis of that yes, it was something that was given emphasis throughout the iterative process that was employed for each round.
And so there was no evidence that the Sport Australia and the published program guidelines were actually being used consistently in the Minister's office?
No, the assessment scores were retained in those spreadsheets throughout, but they weren't then being relied upon as the determining factor, and this is something, so we took evidence from the two key people involved to actually test that that's what the records told us, and their evidence didn't disagree with that. As I say, the evidence to us was it was other considerations were being taken into account, not that they were recorded at the time, and not when we were told after the event what they may have been, that we could either A, see that that is what had actually happened, or any records at the time to demonstrate that here's how it had been applied, because when you're dealing with a body of 1,941 eligible applications assessed as eligible, it's a large body of applications. It's not the sort of thing you can do, if you like, from memory.
So we know then we've got, within the Minister's office, we've got the colour-coded spreadsheet that assesses projects according to whether they're in, which electorate they're in, and whether they're in a target or a marginal electorate. And so it's, your evidence is that that was a criteria. And then there are, you're not sure what the other criteria are. That's correct?
Yes.
Yes. So would that then mean that then the decision-making is very open to being influenced by representations from elsewhere?
Well, as the Auditor General said, we didn't do an audit of representations, but the representations we saw, we would not agree with, if this is what you're suggesting, we would not agree that there was a clear causal relationship between local members of Parliament saying these are the priority projects in my electorate, those that input to the process, and the ones being approved. So, for example, we saw as many instances where a local member would say this is the most important project, or these are the most important projects in my electorate that I'd like to see funded. We saw as much evidence of them not being awarded funding ultimately as we did of them being awarded funding, which got us back to the issue we had. So it's not the assessment against the published merit criteria using the published assessment process that determines success or failure. It's not clearly the case that if a local member said these are the ones that should be approved for funding, that they got approved for funding. Sometimes yes, sometimes no. And with the iterative process, sometimes it would start as a yes and end as a no. Sometimes it would start as a no and end as a yes. And so, and particularly for us in a situation where you're seeing, and say, there isn't a spreadsheet. There's dozens and dozens of versions of this spreadsheet. I think our tally is there's at least 28 versions across the three rounds where a substantive change was made, and essentially a substantive change is between a version. Sometimes the versions will be within hours on the same day. A project would go from being approved to not approved, or not approved to approved, without any record as to, well, what's changed. If you've applied separate unpublished criteria to arrive at a result, well, what changed in that assessment across days within a day to lead to that change? And I say, yes, we saw input from local members. Sometimes that would see a project flagged to be approved and ultimately it wouldn't be approved. Sometimes flagged not to be approved and ultimately... So we're all around the place, but the one thing we can say is there wasn't a record made as to why was this application funded and this application not funded.
Mm-hmm. But at the same time as this was going on, with this what seemed to be a fairly random then assessment, you had dozens of emails going backwards and forwards between the Minister's office and the Prime Minister's office. And the spreadsheets going backwards and forwards and changing.
Sometimes the spreadsheet, sometimes simply communication saying, this member of Parliament, these are the ones that they're fighting for, or sometimes say it would be, didn't involve the Prime Minister's office, a local member or candidate contacting the Minister's office directly and saying, in my electorate or this electorate where I'm running for election, these are the ones I'd like to see approved. I mean, we quote, I think it's in the audit report, we early in chapter 1, there's a footnote saying, well, the check which led to the request for the audit. Well, the candidate for Mayo said, here are the three I'd like to see approval. 2 got up, but 1 didn't.
Mm-hmm. In the, with this spreadsheet going backwards and forwards and the dozens of spreadsheets, the final decision, though, on which projects were being funded was a final version of the spreadsheet. Did you? You saw that spreadsheet?
Yes, in each round, but also bear in mind, and there's a figure, I think it's 4.1 in the report for round 1. We show that even after the Minister has formally recorded her funding decision for round 1, over the course of then a week or 2, there were some changes made post that formal decision, with the Minister's office saying the Minister's changed her mind and this is no longer approved, this is approved. So we tracked each and every version of that, and we could then see, well, it's where we finally ended up. I think that was the 23rd of December, was where 21st of December we got a final position for round 1, even though the decision was recorded on the 7th, I think. Well, in any event, it was after the Minister had signed the brief saying these are the ones I approve for funding.
So, and then it was changed again?
On more than one occasion.
And you had no indication then as to what the representation or what the rationale for that further changes?
No, it wasn't recorded, and when we went through that process of interviewing the senior advisor, these were some of the things we're trying to establish. Okay, there wasn't a record made then, but can we work through, can you tell us now why it was that this one went from being approved to not approved, or went from being not approved to approved? What were the considerations there, so we can try and understand how it is we ended up with this final population of approved projects rather than alternate ones? And
what answer did you get from those advisors?
Generally couldn't recall, and there was no record made at the time.
Despite probing, I'm sure they couldn't recall.
No, we even worked through some examples. To try and jog the memory in terms of showing some of the more some of the examples that we thought might come quickly to memory, such as for the project that scored the highest overall across the whole program with 90 out of 100. Started off in the early iterations of round 1 as being flagged for approval, but then stopped being flagged for approval on the 27th of November and was retained not approved from there on. So the thing was, for a point in time, it was flagged to be approved, then it stopped being approved, so scoring 90 out of 100 sort of stands out. So we said, well, can you remember this one and why it changed from approved to not approved? So we tried to run through some...
And their response to that was?
Couldn't recall.
Couldn't recall. It's certainly, from my perspective, that doesn't look... Yeah, that doesn't really hold water. Did you interview any advisors in the Prime Minister's office?
No.
Did you request to interview them?
No.
No. So there were no... You didn't...
It was clear to us that the decision maker for the program was the then Minister for Sport. So yes, there were various inputs to the process. One of them being the Sport Australia assessment work. That was clearly the spreadsheet being used by the Minister's office was the one provided to them by Sport Australia on the 8th of November, and it remained the basis for that spreadsheet throughout, even though Sport Australia did further assessment work. So at the very end of round 3, the spreadsheet being used includes 1,943 eligible applications, but that population is incorrect. 7 of those applications were withdrawn by the applicant, and on top of that there were 5 new applications came in, but we're still working off an outdated spreadsheet because the spreadsheet was obtained before Sport Australia had completed its work.
There were media reports of an email indicating that the Prime Minister's office directed Minister Mackenzie's office how to allocate the funding. Are you aware of that email?
I don't know what email you're referring to. So we've seen...
Yeah, it was reported on Network 10 that quotes an email from Mackenzie's office. We have just been advised by the PM's office that there have been some projects on the list funded under another grants program. We have been asked to make a slight adjustment.
Yes, we know of that email. We've seen that email. We've seen other emails similar to that email. That was not, if you like, particularly unusual email in the context of the program for us. That's what we're saying in terms of that footnote 46. Some of them were direct representations, which that we would describe...
It's a bit different getting that sort of direct representation from the Prime Minister's office rather than just a backbencher who says, my local bowling club would like to have a grant.
That's in the category we described in the audit report as a direct representation versus an indirect, where simply passing on what some other member has asked for.
I'll reiterate what we said before. The evidence for us was that the Minister was the decision maker in the process. We If we had have identified that someone else was the decision maker in the process, we would have went down that path. So there were representations, both indirect and direct, but at the end of the day, the evidence in front of us was the Minister made all of the decisions. How do you come to that conclusion? Well, not every representation, either direct or indirect, resulted in the outcome. There was balance on all sides of things.
Did you have evidence then of representations from the Prime Minister's office in terms of changes to the spreadsheet that they were recommending that then didn't get, that didn't eventuate?
Yes.
So,
So
okay.
that's part of the evidence why we came to the conclusion that we did, that the Minister was the decision maker. Again, representations aren't an unusual thing in our process.
The question for us, though, is where they come in. The second criterion provided an opportunity for members of Parliament and others to provide support for a project, and invariably in a grant program, that's where members of Parliament provide their support. If there's to be a separate process late in the grant-giving process such as this, these program guidelines didn't outline that members of Parliament would later in the process also have an opportunity to provide this sort of input directly. But the guidelines clearly said that letters of support and other things which would help demonstrate community need and how the project would address what the program's looking to achieve can be provided as part of the supporting material for the application. And certainly there were applications where the supporting material included letters of support from federal, state, local government saying this project, from my perspective, has merit and we support it being funded.
Did you have evidence of emails which were, I suppose, went beyond that representation of just suggesting that a project be considered favourably to any directions from the Prime Minister's office?
Well, I guess it's in terms of directions, as we say, it was a matter of representing from various sources, be it another member of Parliament saying, in my electorate I'd like to see these funded, or here's lists of projects which the government broadly is looking to support with funding. How many of those can be accommodated from within this program? Can they be included on the approved list? And say, some would be included, some would not, some would be included for a period of time but then be excluded later, and some would work the other way. But clearly there was an iterative process there, and it was the Minister's office and the Minister who were in charge of that process, receiving input from various sources, including the Prime Minister's office.
Right. But you say that you actually didn't do a thorough analysis of those representations.
No, what we said is we didn't do an order of representation, so we can't... So, for example, there could have been other representations which didn't come in to the Minister's office through this means, or came into the Prime Minister's office that never came onto the Minister's office that we wouldn't be aware of. What we can say is, from the representations we could see, there isn't a clear and direct relationship that says that if a local member of Parliament said that this is the project, or these are the projects in my electorate which should be funded, that each and every one of them was then funded.
No, but did you consider, though, the difference between making representations from the Prime Minister's office versus, I was saying, just a backbencher?
Yes,
and
we
did. Whether there was more influence from the representation from the Prime Minister's office than other representations?
Yes, and it wasn't the case that we could see that those which came, if I could say, directly from the Prime Minister's office were necessarily any more successful than those which came from a local member direct to the Minister's office rather than through the Prime Minister's office.
Okay. I mean, based on the evidence available to you, what parties did the Prime Minister's office make representations on behalf of?
The only ones we saw were coalition.
So, and were they all on behalf of MPs?
Some were from candidates, or as in people that were hoping to be elected to Parliament and weren't in Parliament.
Okay, and how about the Liberal Party or campaign teams or its state bodies? Were there representations from those via the PM?
I recall at least one where it was the state body who was, because there wasn't yet, I understand, who were pulling together the list for that electorate and then provided that to the Minister's office. So you've got this, the process involved, as we understand, a thing called, initially they were called wish lists, then they became what was called fighting for, which these are the projects I'm fighting for, and those lists were identifying, and it wasn't just for this program, it was broadly that these are the projects in this electorate that we're looking to secure funding for, And so those were being put together, and some of those were coming through to the Minister's office saying, can this be accommodated within CSIG? Some of those would be an existing application, some of them were not an application and never became an application.
Right. Were there representations other than from coalition-aligned members of Parliament or the Liberal Party or their campaign bodies?
If there were, they weren't in the records.
Thank you.
Senator Roberts.
Thank you very much. A lot of emphasis on footnote 46. Can I just seek to clarify that in relation to footnote 46, we are told the Minister's Office recorded on the 20th of November 2018 that it had, and then it's the third dot point, taken into account representations received from a number of senators and members, footnote 46.
That's correct, yes.
As a result of which, the evidence available, etc., relates that footnote about directly and indirectly making representations is in relation to senators and members only.
Yes, that's where...
Yeah, yes, that's correct.
Yes.
Yeah, look, thank you. Just wanted to clarify that. Next issue I seek to clarify, you did find that no ineligible project or application was funded.
No, Senator, that's not what we found. So if you go to the start of Chapter 3, which is the chapter on assessment, the finding there was ineligible applications were identified and no applications assessed as ineligible were awarded grant funding. So that's the Sport Australia eligibility assessment process. What then happened subsequently was there's applications, late applications were taken on board which were ineligible under the guidelines. Amendments were made to 4 existing applications which were ineligible under the guidelines and they were funded. But at the time, so this relates to the Sport Australia assessment process. Sport Australia removed from its list those it assessed as ineligible is what that finding is. Subsequent to that, as I say, there were the 5 new applications, the 4 amended applications, and then because things took longer, because you were now running 2 rounds rather than 3 and funding agreements were in place, you had 8 projects where, according to the details provided by the proponent, the project had been completed before the funding agreement was signed. They're ineligible under the program. And there were 270-something where the project had started before the funding agreement was in place, which is also ineligible under the program. So we get to around 43% of those which were awarded funding. By the time the funding agreement signed, were ineligible.
Sorry, how many was that?
So 43%, 290...
That's paragraphs 432 and 433.
Yep.
Paragraphs 432 and 433.
It was 272.
Can I just...
of course.
With your agreement, Senator Roberts, on page 9 of the report...
Yeah, page 9.
In paragraph 16 in the summary, it says, ineligible applications were identified and no applications assessed as ineligible were awarded grant funding.
That's correct. That's
so I'm just struggling to...
So that's the Sport Australia assessment of ineligibility. But what happened after Sport Australia had finished its assessment work was a couple of things. 5 new applications were taken on in March 2019.
Right.
Sport Australia finished its eligibility checking of the applications received by the closing date in November 2018.
Right.
So in March 2019, 5 new applications.
Right.
4 amended applications also in March 2019, and then they were signing funding agreements across into calendar 2019, and the guidelines eligibility requirements don't end just when you've lodged your application, and this is common across many grant programs. If you've completed your work, or in some cases, as in this one, you've even started your work before a funding agreement's signed, you're not eligible to receive funding. And so what we point out
under this program, other factors could be taken into account, and that was always up there in lights, wasn't it?
Just before we get... That's a slightly different point. But let's just take it through step by step here. So the 5, I think you mentioned 5 new applications that came in March, was it, 2019? Yes. Were they assessed as ineligible by Sports Australia?
No.
Right.
But Sport Australia raised with the Minister's office at the time.
But they weren't assessed as ineligible?
No, because it had finished its assessment.
I get that. But did those 5 projects get funded?
Yes.
Yeah, but they weren't assessed as ineligible?
No, they weren't assessed as ineligible.
That's right.
Right, thank
So,
you.
so there were.
That was my question.
I'm still trying to go back to Senator Betts's original question. Was there a project that received funding that was assessed as ineligible by Sports Australia?
No.
Okay.
But the question was
Can I
were they
then
all
move
eligible?
on to ministerial approval? And that was always part of the process that was put out to the public, that the minister...
It was what was put to the public, yes.
Yes.
It wasn't always part of the process.
Sorry?
It wasn't always part of the process. Sport Australia originally designed the program on the basis that it would be the decision maker, which is as a corporate Commonwealth entity, and that's how its framework is based. But it was through the development of the program guidelines engaging with the Department of Health and the Minister's Office, they were told the Minister wished to be approver rather than Sport Australia. But the published guidelines only ever had the Minister as approver.
Yeah, the publicly released guidelines clearly stated that the Minister was the final decision maker. 8.1, final approval.
Yes.
Starts off, the Minister for Sport will provide final approval.
Yes.
In addition to the application and supporting material, other factors may be considered when deciding which projects to fund.
Yes.
That was up there in lights, part of the application process.
Part of the program guidelines, yes.
Yep, look, thank you for that. And then you expressed some concern that the legal authority for the Minister was not evident to approve these projects. Did you seek any legal advice as to put yourselves out of the misery of whether knowing or not knowing whether the Minister had this capacity?
What we identified during the audit was that the Department of Health and Sport Australia had raised issues internally about the Minister's legal authority to undertake the approval process, and that's set out in the audit report. We asked them whether they'd sought any legal advice to ascertain that, and they hadn't done so after raising those concerns. We also looked at the legislation that applies with respect to Sport Australia, and that's the Sport Australia Act, and Sport Australia is a corporate Commonwealth entity separate from the Crown, which makes decisions in its own right, and it also includes a ministerial direction process. On the basis of and that's some of the concerns that were raised in Sport Australia and the Department of Health. On the basis of that, it wasn't clear to me where that authority came from. Did I seek any legal advice? No. Because that was the responsibility, in my view, of the department and Sport Australia to be very clear about that once they're raising those concerns. And it's also their responsibility to inform the Minister if they have such concerns and not put the Minister in a situation where they may not have legal authority. And that's what my report points to. I don't think it's the Audit Officer's responsibility to determine the legal obligations of ministers or others. It's up to the entities to assure themselves of their authority. So that's why we didn't undertake legal advice. We put it in the draft report. We questioned the department about whether they'd satisfied themselves. They said they hadn't.
Right, but the Minister was told that the legal capacity was there.
I don't understand that there was any advice to the Minister with respect to the legal capacity.
Right,
There was
but
no
with 8.1 that I read out before, that the Minister is the final decision maker, that was drafted by the department.
Drafted by Sport Australia.
Sports Australia, that's what I meant. And what would alert the Minister or anybody else to the fact that there might be some questions raised about that?
As the Auditor General was saying, that was part of our criticism of Sport Australia and Department of Health is that...
but for the Minister,
Yep, that's what I'm saying, the Minister...
I can understand the criticism in relation to Sports Australia, but that criticism, I would suggest to you, should not flow over to the Minister.
I think the report's, the primary criticism that we put in is to Sport Australia and the Department of Health for not clarifying those things, and that's certainly my view that that's a primary role of departments and authorities to make sure that ministers are aware of their legal authority.
It's one of the key messages at the end of the report summary that these things need to be addressed. An important element in designing a robust governance framework for a grant program.
No dispute there, just wondering as to where the buck stops on that one, and clearly it's with Sports Australia from your report.
And the Department of Health.
Yeah, with the bureaucracy, let's use that terminology. And Senator Canavan has a follow-up.
Just a quick follow-up. So just to clarify, there was no evidence before yourself through this inquiry that the Minister lacked legal authority to make decisions on this program?
The evidence to us was that Sport Australia expressed a view during the audit that they didn't believe that the Minister had authority, that they were the decision-making body as a corporate Commonwealth entity, and that the Department of Health raised concerns and said that they should get legal advice.
But I'll just repeat the question. It was a yes or no question. There was no legal advice before you to indicate that the Minister lacked legal authority to make the decision?
No.
Thanks.
Thank you. And then in relation to legal requirements, under this scheme, right, wrong or indifferent, there is no legal requirement for the reasons to be documented. That's correct?
That's correct. That's why we put in the recommendation.
You are critical of that, but as the situation stands as of today, there was no legal requirement.
That's really dodgy.
7.1.
Correct. The Commonwealth grant rules and guidelines don't apply to this program. And the Sport Australia grants framework, which
look, it's paragraph
can't be applied to the
23,
Minister.
page 11 of your report that I'm reading. There is no legal requirement for the reasons to be documented. I just wanted that confirmed on the Hansard record. Look, thank you for that. And then can I move there's been some concern about target seats, and where are we? Page 56. Paragraph 4.36, first dot point, last paragraph. Target projects that were located in electorates held by the Australian Labor Party received a similar amount to what they would have received had funding been awarded on the basis of assessed merit. That's correct?
That's correct.
Right. So that is the undisputed fact. We can try to spin things politically, but your finding is that target projects within Labor-held electorates, they would have received the same funding awarded on the basis of assessed merit.
And targeted by the coalition. And is that what targeted means?
That's what targeted means.
Well, we had that before, and that's the clear evidence. So whether the seat was targeted or not as an assessment or based on merit, those seats... Excuse me, we'll listen to your nonsensical questions in silence. Please allow us to ask our questions, which are a lot more robust, in silence. Now, can I ask, in relation to these targeted seats, the evidence is that those seats, if it was only based on the assessed merit, and we can get there later as to the robustness of the assessed merit, but they got the same amount of money, irrespective of whether it would have been done solely on the assessed merit or because they were targeted.
Yes, the amounts are similar, as we say in the audit report.
The amounts are similar. And so, all right, look, that stands to... you've got another one?
Different topic, though.
I wanted to go on the basis of the assessment that was made, and your report refers to the people charged with making the assessments having quite a diversity of approach in their assessment. So, for example, where two people were assessing the same project, you had a diversion of up to 30 points between the two assessors. 30%. Well, it was out of 100, so it was 30 or 30%, same diff, we're both right. That's correct, is it?
We talk about that in the audit report, yes.
Yes. So two people making these assessments on merit, one could have given it 100%, and somebody else 70%. That's a 30% diversion. So one of them would have allowed it to go right through, sail through, and the other one would have been below that magic figure of 74 and not allowed on merit assessment. It's not a very robust and objective system, is it?
Except that's only one part of the system, Senator. So following that assessment process, which is the Sport Australia assessment team, there was then an assessment panel which was chaired by a Sport Australia person again, but included the Deputy Chair of the Sport Australia Board, a representative from the ACT Government, a representative from the Department of Health, and they themselves examined all of the assessment work to make sure that they were satisfied, above the work of the assessment team, that the assessment results were robust and could be relied upon. And then all of that work then separately went to the Sport Australia Board, which has again, diversity of experience and expertise on it, so that they themselves could see all of the assessment work and the results and satisfy themselves. And to demonstrate that it wasn't just, if you like, a tick and flick, the assessment panel said there's actually 4 of those which, based on the assessment work, the assessors say should be supported that we don't agree with. And they said there's 8 others where we looked at the assessment work we think should be supported, so they were added in, so 4 off, 8 on. Went to the board. The board was fully satisfied, it would seem, with all of the assessment work, and they endorsed that position, which was to say that's now stage 4. Stage 3 was the panel, stage 2 was the merit assessment by the team, stage 1 was eligibility checking.
Well, eligibility, we can go through that as well, where projects were initially determined to be eligible and then determined to be ineligible, and also the other way around, ineligible and then became eligible. And most of those assessments were made by just one individual or by one person. Is that correct?
Yes, but at 3 points. So an individual at 3 points.
Step by step, by one person. But Senator Rice, can you just hold it? We paid you the courtesy. So one person made that decision. What qualifications, what experience did they have to make these assessments? Did you make any comments about that?
Yes, so they were people with experience in
Sorry?
They were people with experience in the sport funding area, so they were all program employees. They weren't contractors or people outside the Sport Australia. They were within the area responsible for designing and implementing this grant program.
Now, wait a minute, not the program itself, but given all your findings, you're saying they had all this experience, but you've made quite a few findings, have you not, about difficulties in the design of the program? Is that correct?
Yes, we make some observations. For example, we say the eligibility criteria in places could have been clearer. So one of the things we observed was that there were 4 applications funded for electronic scoreboards which were assessed as eligible, but there are others which were assessed as ineligible because they were electronic scoreboards. So either there's another 4 ineligible applications funded, or there's others who were denied the opportunity to compete for funding.
Can I just take you to paragraph 2.23 of your own report, second sentence? No formal training was provided to the assessors.
Correct.
Right.
That's correct, Senator.
So they had no...
provided to Senator McKenzie?
Chair, can you please control your own? That is your task, your role.
You'll have another time.
The reason we're running out of time is because of the interjections from your side, and we have been exceptionally well disciplined. So these people making these assessments, you accept, had no formal training to undertake the assessments.
Well, I wouldn't say we accepted it. It's what we found, because it's one of the questions we asked.
All right,
were they
you
formally
found
trained?
they had no formal training.
Senator Betts,
Correct.
excuse me, let the witness give his full testimony rather than
Thank you for
continuing
your
in here.
intervention, Chair, and I now expect it with interjections from your side. But I accept your point of order.
Yes, Senator, that's what we found, that they
Right,
hadn't been.
thank you.
Because that was one of the questions we asked, is had they been formally trained?
So if they had no formal qualifications, there's no speciality there, then, is there?
Well, if you go on to the remainder of that paragraph, Senator, what we then said, OK, in the absence of formal training, we then put it to Sport Australia, what else did you do to ensure the quality of the assessment work?
Do you want to follow up now?
So we looked at the fact that they were involved in the development of the guidelines and the development of the assessment methodology. We looked at whether, as a team, okay, you hadn't received formal training, did you actually meet collectively to discuss and make sure that we're doing things in a consistent way that is of an appropriate standard. We looked at whether there was any other material in terms of to support how you go about assessing the applications, which there were. The actual way they designed, we looked at the way they designed the assessment forms, if I put it that way, within their online system to make sure were you working through each element of the program guidelines which said would be taken into account here, and how you recorded what you considered in reaching a view as to how you would score each application against each sub-criterion.
Yeah, but on some occasions where two individuals assessed the same application, there was a deviation of 30% or 30 points between. So the objectivity of it, if you were sitting an exam and two examiners were marking your paper and one of them thought that you were worth 70%, you'd be pretty happy with that. The other one saying you're worth only 40%. Yep. It could be pretty devastating to your future academic career. And similarly with these projects, we had assessors that were coming to substantially different conclusions, at least at the initial merit assessment. That's correct?
Yes.
That's correct?
That's correct.
Correct?
And it's
Chair, excuse me, did you hear my comment before? Would you mind closing down your side when we're asking questions?
That's correct, Senator. And
right,
in a way, as soon as you have a process which has more than one assessor, there's always that risk. That's why it's important that we see that possibility be planned for and addressed in the assessment process, because it's not a mathematical equation here, that judgment is being applied. And so it was important for us to see how did you then go about addressing those differences, which there's always likely to be differences when you're applying judgment to assessing applications against merit criteria. So how did you address that in the assessment team? But perhaps as important, if not more importantly, what then happens after that to see that there's processes outside that core assessment team so that other people who are independent to that process apply their minds as well, which is, say, then the third stage was the assessment panel, and then the fourth stage was the board.
Yeah, but the third...
Thanks, Senator Abetz. We'll close there for a short break. The committee will now suspend for a short break and we'll recommence at 6 p.m. All right, we'll resume this hearing. I'll hand to Senator Green.
Thank you. Can I just go back to the conversation we were having earlier around direct and indirect representations? You mentioned that there were some representations, well, in the report you refer to members and senators, but you've told us today that there were representations made by various sources. So I just would really like to understand exactly who those various sources were. You mentioned the state body of one state body of the coalition.
So the report also mentions, if you go to footnote 5 on page 17, the fact in terms of there's one instance of a candidate. So yes, footnote 46, which comes off paragraph 320, talks about senators and members. As the Auditor General said earlier, this wasn't an audit of representations. The thing for us was to understand what was the assessment and decision-making process for the award of funding. It was in response to that record of 20 November saying this was one thing being considered. The evidence we took under oath from people saying, yes, these were taken into consideration. Thing for us to try and see to what extent were representations being provided and what impact were they having on the award of funding.
I understand I'm not asking you about an audit of representations. I'm seeking to understand that question as well.
Yep.
All of the changes that were made to the spreadsheets, the various versions that you're referring to, I just want to know when those representations were made and who they were made by. And you've referred to a state body of, is it the Liberal Party, the National Party? You said a state body.
So in some cases, the sitting member isn't a member of the current government, and so in terms of what's the list of projects which say the sorry,
are you talking about a candidate?
Well, in some cases, a candidate had yet been appointed. So, for example, I can recall one electorate where the Minister's office was coordinating what would be the likely list of projects we'd be looking to support in that electorate when a candidate is appointed. Because, I mean, bear in mind, the funding rounds ran from September 2018, which is when applications closed, right through to April 2019. So it's a long period of time there. Candidates, as we understood it, weren't always in place from the beginning of the process when this grant program was being run.
So when a candidate wasn't in place, the representations were being made by the state body of the party?
Well, so I just said I could recall in one instance, yes, it was the state body of the relevant political party that was saying, I'm pulling together a list of projects which we want to support in this electorate.
Which party and which state was it?
So that was in Queensland, is my recollection.
The Queensland Liberal Party? Queensland Liberal National Party?
I think it's LNP in that state.
LNP. And they were the ones making the representations?
Well, they were pulling together a list of projects we'd like to support in this electorate to provide into the Minister's office as a process, saying here's the ones we're looking for in this electorate, which ones can be supported through this program.
Yeah. And do you recall whether that was a marginal target seat?
I recall it was a marginal seat by the AEC, but that doesn't necessarily mean it was a marginal seat in the spreadsheet, if you understand the distinction I'm drawing.
I do.
So I think the answer to the question
I
is
do
no.
know the
No,
difference.
he doesn't recall about the marginal in the spreadsheet.
Was it held by the coalition or another party?
By Labor.
Okay. So the state LNP office sent a wish list of projects in a Labor-held seat.
I believe it was called a Fighting For list.
The Fighting For list. Okay. Do you know what seat it was?
Yes.
Would you like to tell me?
Longman.
Longman. Okay. Did you get similar representations in regards to other seats in Queensland?
No, I can't recall another one in Queensland. Obviously, I can recall other ones in other states. The report mentions Mayo.
Yep. Okay. And there were other, when you say various sources, so we've spoken a lot about local members making representations, members of parliament in regards to their own electorate. Did senators make representations on behalf of non-held seats?
As in like the duty senator type arrangement?
Yeah, because that's quite, I guess
so
that would be how...
I don't recall one I don't recall one of that nature, no.
Well, if senators were making representations, what seats were they making representations for?
Well, so for example, Indi would be one seat, but that was, in that case, as I mentioned, the Minister's office, well, she's a senator, but her office was pulling together the list for Indi, because at that point in time the candidate had yet to be selected.
Mm-hmm.
But so I don't recall other senators, as what we understand being the duty senator arrangement, coordinating the Fighting For list for other electorates where it wasn't a sitting coalition member.
Was it always called Fighting For? Was that a uniform...
The records we saw, it was initially called Wish List, and then it became called Fighting For. But I keep saying, and I appreciate your response, but it's simply the case, this wasn't an audit of representation, so what we've seen is here were the inputs that were being provided into the Minister's office as part of the award of funding under the 3 rounds, some of which were of that nature, but there are other inputs as well, including the Sport Australia results of their assessment process.
Okay. Can I ask you about some of the evidence that you received? I just want to make sure, this has gotten a lot of media attention, and I just wanted to ask whether all the evidence that you've collected during the audit and evidence that might have been reported publicly since then, are you satisfied that you've received all the relevant evidence?
I mean, under the standards, what we try to do is collect sufficient evidence to assure ourselves we can can draw a conclusion. The processes we put in place led us to the view that we have collected sufficient evidence for that. We're pretty diligent in getting information together, so I can't say that there isn't something that wasn't collected in our evidence gathering process, of course, but...
Is there any evidence that you sought and you didn't receive?
No.
And were there any witnesses that you wanted to interview that didn't make themselves available or were less than sort of forthcoming in their interviews?
The Parliament has given us very extensive powers with respect to the collection of evidence. So we didn't have a situation where we were denied access to information that we asked for. I can't say on all occasions that everyone's happy to be involved in the process. So,
sure.
But
so there's a difference though than when you had to invoke those powers. Did you have to invoke those powers to compel witnesses?
We invoked our powers for interview processes in this audit, and I decided to do that not so much because witnesses have said they wouldn't make themselves available, but when we created all the evidence together, we wanted, which is presented in the report, I wanted to get representations. In this case, it was from ministerial staff that gave us some assurance that we weren't missing something within the evidence base that we'd pulled together. And I decided that the best way to get evidence from an interview which could stand up against documentary evidence was to take that evidence under oath, under compulsion, rather than a voluntary process, because evidence under oath lifts up the standard that I think you can take the evidence as being robust under. So we used our compulsion powers in this sense just to get the level of evidence from an interview to a standard which, if it did challenge our documentary evidence, we could balance it that way more effectively. So I didn't do it to force someone to do something they didn't want to. It never really got to that stage in the first place.
Okay.
Can I just follow up there where you say it never really got to that stage? What do you mean by that?
I decided that the standard of evidence I wanted was something that should be done under oath, which requires the compulsion powers, rather than asking the person to come along and do an interview. So I wanted to lift up the level of evidence.
So it wasn't. So you had issued a notice or that you were wanting to formally interview people. Is that right? And
no, I made a decision that we should interview people and decided that should be done under oath, so I issued a notice under...
So that was at the beginning of the process?
This was at the end of the process when we'd collected all of the documentary evidence and gone through all of that, and we wanted to test that documentary evidence against...
So you didn't have any witnesses who refused to be interviewed?
No. Well, when you go down the compulsion path, they can't refuse.
Yeah, so I'm asking it before that.
No, I don't think so.
No, we hadn't approached those people beforehand.
Did you interview the Minister for Sport?
No.
Sorry.
That's okay. Just going back to the evidence that you received, the spreadsheets that you've referred to, the ones that have gone back and forth between the Prime Minister's office and the Minister's office, and presumably Sports Australia as well. Can you explain to me a little bit about that spreadsheet? And you've said there's various versions of the spreadsheet and what information the spreadsheet had?
Yes, so I think it's important to be clear, not every version was a version sent either back or forth with the Prime Minister's office or back and forth with Sport Australia. Some of it is simply being worked over within the Minister's office. So forgive me if I'm talking at the wrong level, but the spreadsheets have more than one sheet in them. Mm-hmm. So there's one sheet which has each of the 1,943 applications which were being considered, and so that would have key aspects around those. So it's not everything about the application. It would have, for example, which stream you'd applied for. Each application, when you lodge through an online grant system, nothing unusual about this, gets given a unique identifier. So unique identifier, the score awarded through the merit assessment process, who the applicant was, the title of the project, the amount of money they were seeking, the total value for the project, because invariably the Commonwealth's not being asked to fully fund a project. There's a total project value. We're being asked to contribute towards it, those things. The electorate, the party, a flag column as to whether you were going to be successful or not, as at that point in time, the state, the electorate status we mentioned earlier.
The electorate said as
Yeah,
marginal?
Marginal, targeted, blank.
Okay, those were the three
Yep.
classifications.
Yep. A brief description of the project. And then that's in one sheet, which is, if you like, that's the one it's referred to as the colour-coded sheet. There's then a second sheet in the spreadsheet which essentially has 4 tables in it. One is a summary table, the total number of projects expected to be successful and the amount of project funding, so that gets updated as the flagging as to whether you're yes or no to be approved changes. There's a table by state as to applications received, dollars and the success rates. There's another table by political party, aggregating them by political party. And there's a third table which for each individual electorate lists the applications received, the dollars, the amount at this point in time proposing to be approved and the dollars proposing to be approved for the one or more applications proposing to be approved in that electorate with a success rate calculated. So there's essentially those 2 sheets to the spreadsheet.
Yeah, I understand.
So that's what I'm saying, the spreadsheet is more than one sheet, if that makes sense.
Yes, that does.
And in terms of the original request from the Minister was quite early in the, well, as it was prior to the final assessment of the project, she asked for a list of all of the...
She didn't, her office did.
Her office asked for a list. That came across from Sports Australia in a spreadsheet form. Is that right?
Sport Australia initially, the first request was 26th of September 2019. Sport Australia the first couple of times provided very summary aggregate information because they hadn't progressed the assessment process very far. It was really starting on about 8 November when they started because what they were providing hadn't met the needs of what the Minister's Office was seeking, was when they started providing the first spreadsheet which listed each individual application, which at that point was still on the table because, as I mentioned, the 8 November one, which is the spreadsheet used as the basis throughout all the rounds, had 1,943 applications assessed as eligible, which is, Senator Betts's questions there. Well, the eligibility assessment went back and forth a bit, so there were actually 7 of those which weren't reassessed as ineligible, but they were actually applications the applicant later withdrew, so that brought the population down to effectively 1,936. But as we say, things were moving in terms of eligibility and so forth, so the true application population at that time should have been 1,941.
So were you able to, from the evidence, understand when columns targeted, marginal, other appeared in the spreadsheet?
Yes.
Were they done at Sports Australia?
No, they were done in the Minister's Office. Sport Australia never saw those columns.
So they didn't go back and forth to the department or to the agency?
At points in time, what went back from the Minister's Office to Sport Australia, that column in the spreadsheet wasn't included.
So they took it out when it was going back and forward?
Well,
if it was going... So if it was being sent back to the Sports Australia, that column weren't in the documents?
That's correct.
Those 3 columns?
No, the electorate and party was in the spreadsheet that Sport Australia offered up. What happened was the Minister's Office colour-coded those, but those columns are always there, and those columns with the colour coding stayed in when the Minister's Office would send back spreadsheets at the point in time saying these are the ones that are being approved. Those columns with the colour coding stayed in, but the column added which said electorate status wasn't included.
Right. And so that was included by the Minister's Office at some point in time?
Yes.
After the 8th of November?
So we can see, looking at the versions, at which point in time it came in. So it's, for example, the 20 November 2018 version has it in there.
Right, okay. And why would Sports... No, you will get 20 minutes. Why would... so Sports Australia did include who held the seat, the electorate, and who held the seat in their original advice to the Minister? No,
that was what... So the original advice was at a more broad level.
Right.
But when they were providing the information at an individual project level, they were specifically asked to include that information.
By?
The Minister's Office.
Right, okay. I'm just conscious of time, so I will quickly... I've just got a couple of questions over any involvement, Mr He, you may have had over the Gaetjens report. whether you were advised that the Gaetjens report was being commissioned. How did you become aware of it?
I think I became aware of it when it was announced, is my recollection.
So in public, in sort of public commentary?
And I think it was around the 28th of January.
You weren't advised ahead of time that...
No.
Okay.
And we had some conversations. I had some conversations with Mr. Gaetjen, and the office had some other conversations where we tried to assist them to source where they could source some of the evidence.
You weren't asked to provide evidence to them, or...?
My act under section 36 doesn't allow me to provide audit evidence to anyone except in the course of an audit, and the audit's finished, so so I can't provide it. But what we did provide, we did basically say the information we refer to in the report is on this server.
On this server?
Yeah, the health server.
Oh, right.
No, it wasn't a very specific. This is where we got it from.
Okay, so you redirected him. You directed him to where he might be able to find that report. So you said you had a couple of conversations with him.
That was in the context of, that was the conversation prior to the release of the report. Okay. Had one conversation afterwards, I think, but...
Do you have anything I noticed, we don't know what's in the Gaetjens report. I presume you haven't seen it either. No. Okay. All we know, and some comments that where the Prime Minister quotes from the report, and he quotes that, and I quote that on the 2nd of February, that Mr. Gaetjens, he refers to him as he, did not find evidence that this process was unduly influenced by reference to marginal or targeted electorates. And I'm just wondering how that lines up with your comment in the report, which says that you did find distribution bias in the application of the grants.
I'm not aware of the terms of reference for the review. The analysis was undertaken, the evidence that they used, and like you, I haven't seen the report, so I can't really comment on that commentary.
Okay. All right.
Would you say it is contradictory, though, to your audit report?
I wouldn't make any commentary on it because I'd be speculating about it, and that's not what we do. For it to be contradictory, I'd need to see it and make an assessment of it, so I wouldn't like to make any comment on that.
Whether the comment from the Prime Minister is contradictory to the audit report?
Again, the Prime Minister's comments relate, from what I understand, relate to the report prepared by Mr. Gaetjens, and that, as I haven't seen the report or the analysis underpinning it or the question that it's asked, I wouldn't know whether it's contradictory or not. So I don't think I'm in a position to answer that question.
Chair, could I just raise a point of order? We have agreed, I thought, 20-minute blocks, and I think we've had 20 minutes since resumption.
I'm about 19 minutes, and I've just
one more
issue. In relation to the documents which we have been talking about today, in particular, I think the spreadsheet of the 8th of November in various forms, are you in a position to table that information for the use of the committee?
I'd like to take that on notice. I believe that the Senate has requested the production of that document, and that's being considered by the government. I didn't consider in my audit the necessity to publish that information in order to produce the report, and as I've talked about previously, what we do with the report is we put all the information in it and then give it to the relevant people so they can look at to make an assessment about it, both in terms of whether they agree with the evidence, but also gives them an opportunity to argue whether it should be made public or not. I haven't done that process. For me to provide you with that information, I believe that I'd need to go through that process as I would have done if it had been an audit report. So I'd prefer to take that on notice and adopt such a process and see how the government answers the question.
Fair enough.
Thanks, Senator Gallagher. Senator Rice.
Thanks, Chair.
I mean, Senator Ross already had 20 minutes. Can I just check? So we're going to allocate a third time to Labor, a third to Greens, and a third to Coalition. Is that your decision?
As we agreed.
So
at the start.
just to that was not agreed. Sorry, we agreed to 20-minute blocks. We did not agree to that proportion. But I just want to put on record then that Senator Rice will be receiving a third of the time, despite representing only a fifth of this committee. That's not reflective of the Senate's decision to establish a committee that has 4/5 of its members as government or non-government senators, or Labor senators, I should say. So I don't think that is fair, and it's also a reflection of the biased and skewed process here for this inquiry, which is not about getting to the details, but is all about running a political process for the Australian Labor Party and the Australian Greens.
Do you know what else wasn't fair? The distribution of the sports rorts money either.
Well, we're trying to establish that. We're trying to establish that, but we can establish that you are not running a fair process here.
We now no longer need to have a hearing
Thank you.
because the chair's already made up his mind
Thank you.
on the public record. What a disgrace.
That's right. Can I recap? The process for allocating the grants in the Minister's office, beyond the location and the spreadsheet with the columns about the status of the electorate, you couldn't determine what criteria were being used to make the final decisions, and that the Minister's advisors that you spoke to in many instances couldn't recall what those criteria were.
Sure. As I read out a short time ago in terms of the contents of that spreadsheet, which is a decision-making spreadsheet, the Sport Australia Merit Assessment score was included, so obviously that was something on the table throughout each version of the spreadsheet. The electorate status column was included, as were the other information about the political party that held relevant electorate. There was some summary information as to the applications, but the Minister's office and the Minister never saw the actual applications. There was nothing else in there that indicated what other criteria might be being applied in that consideration process.
Okay, and it wasn't documented.
Sorry, with the exception as set out in Appendix 5 is evidence provided to us by the Chief of Staff about what he believed the criteria was.
Yes. And that was as evidence given to us when we took testimony from him after the event, not at the time.
Okay. But that wasn't documented at the time. That was post.
And as you'll see in Chapter 4 of the report, we tried to, with some of those, actually work through and say, can we see how that actually worked in practice?
So, and what you said in your reference just before was that you felt that the Minister was being the final decision maker, and given that her staff couldn't recall, it was the Minister that was doing making those final decisions.
That's what all the evidence says, including the testimony, and there's no evidence to a contrary position.
Okay. But you didn't interview Minister McKenzie?
When we provided her with the proposed report, we made an offer if she wished to meet and discuss the report.
Would you have liked to have interviewed Minister McKenzie?
If we wanted to interview her, we would have. We felt we had sufficient evidence to come to the conclusion that we did, and when we gave the Minister the appropriate amount of the required amount of opportunity to provide us with any contrary view with respect to the evidence that we put out in the report. So I was comfortable with the process.
Okay. And she didn't request, having been given that draft report, then she didn't request to put her position?
She didn't provide a response to the Section 19 draft report that was provided to her.
Okay, thank you. When the Minister's office requested a copy of the blank form on the 4th of March, what was your understanding of the purpose behind that request?
Well, the background of that was period before that, the Prime Minister's office had indicated to the Minister's office that there were some projects which had missed the application cut-off deadline and that wished to be submitted to be considered under the program. So on the basis of that, the Minister's office sought to obtain from Sport Australia application forms so that those people could then complete an application which could then be assessed by Sport Australia against the published criteria.
Right. Would you say that's fairly unusual given that the applications had already closed?
It's certainly not consistent with what the guidelines said would happen.
Right. And so in Appendix 4, paragraph 17, you reference 6 extra projects that had already been identified by the 4th of March. And were any of these 6 extra projects included in the group of those 4 submitted and the 5 new applications provided by the Minister's Office on the 20th of March?
Sorry, Senator, I missed your reference there.
It's Appendix 4, paragraph 17. It's saying that there are 6 extra projects that had been identified by the 4th of March.
Yes.
Yes, so they were included in that group of 9 new projects.
Yes.
Yeah. And were any of those projects, those 6 extra were included in those 9 new and resubmitted applications, were they funded?
Each of the 9 was funded.
Right. Can you tell us which projects they are?
I think that probably goes to the broader question around the spreadsheet.
We'll take that on notice.
Okay. Well, can you say whether one of those projects was the $500,000 grant for the Hawthorn Malvern Hockey Centre announced on the 26th of April last year?
If you bear with me for a second, Senator.
We'll take that on notice. I think I don't want to give a false thing when us running through spreadsheets and doing it on the run. I'd be concerned that we mightn't give you the correct answer. So I'd prefer to take that on notice.
Okay. Paragraph 417 of your report refers to finalising a list for round 1 between the 10th and the 20th of December 2018. Was there a more specific date that you could say the list was finalised?
No, if you look at figure 4.1 in that chapter, Senator, you'll see that the list was amended and adjusted at different dates in that period, which is why we say over the period rather than at a single point in time.
So were there projects that were confirmed before the 20th of December 2018?
Yes, there was. The movements were at the margin, if I put it that way.
Right. So before the 20th of 18, was there any involvement from any other Minister's Office in decision making on this list between the 10th and the 20th?
Not that we saw, Senator.
Right. So was there representations from the Prime Minister's Office?
The representations particularly related to rounds 2 and 3, and most particularly to round 3.
Right. Okay. It was just of note that Christopher Pine announced a grant on the 18th of December 2018, and you weren't aware of any representation from people that were then making such announcements?
The last section of Chapter 4 of the report talks about the announcement process, including looking at whether announcements were made, the timing in which people were informed that grants had been approved, and then the announcements that ran with that.
Right. I want to go back to the spreadsheet, or the spreadsheets, which the multiple spreadsheets, you say, and you've talked about having many representations from many different people, all, however, coalition-related MPs, candidates or entities. But just to confirm again that the spreadsheets only went backwards and forwards between Sport Australia, the Minister's Office and the Prime Minister's Office.
Correct, but as I say, we didn't audit representation, so if the Prime Minister's Office, for example, they'd gone anywhere other than the Minister's Office, we wouldn't be aware or privy of that.
So, I'm sorry, I missed. So if...
So our approach was we were looking at the decision making here, as say, was taken by the then Minister for Sport and within her office. Now we're looking at what was coming in and out of there to impact upon that decision making process. If what had come out of that office and gone elsewhere had then gone to other entities that we weren't auditing, well, we wouldn't be aware of that.
Right, but you weren't aware of the spreadsheet going elsewhere, other than
certainly not out of the Minister's Office. No.
Right.
The evidence that we had related to communications from the Minister's Office, not elsewhere, so we can our evidence only goes to that point.
Okay, so it might have gone, given the spreadsheet was in the Prime Minister's Office, it could have gone elsewhere from there.
And we didn't undertake an audit of that, so we can't speculate on it, so we can't make any comment.
What I wanted to confirm, though, that the changes that were made to that spreadsheet, there was the initial spreadsheet that Sport Australia gave the Minister's Office. Were you aware of further changes from Sports Australia to that spreadsheet beyond when they initially handed it over to the Minister's Office?
there were changes within their systems in terms of when they finally completed their assessment work. But the actual...
the decisions on which projects were going to be recommended
that work
for
wasn't
funding.
reflected in, and that's why we say the spreadsheet being worked on it right to the end of round 3 was still, the starting point was that 8 November spreadsheet. So, for example, the 5 new applications, they were only appended very late at the very bottom without the same amount of information as the others, because there was never, at no point did we get an updated spreadsheet of what we're finally left with as a fully assessed population.
But those 5 new applications, did they go through any Sport Australia process at
Yes,
all?
they were assessed against the eligibility and merit criteria by Sport Australia.
Right, and then they were just appended to the spreadsheet. In terms of which projects were being recommended for funding, was the Prime Minister, the version of the spreadsheet coming from the Prime Minister's office back to the Minister's office? Were there changes as to were they making changes to what was being recommended for funding?
Yeah, not in the evidence we saw, it was, their spreadsheet would go out, and to the extent there was any input, it would come back in the email form talking about individual projects, not as here's a revised spreadsheet.
Right. Okay, so the spreadsheet would go out and then you'd get emails that would come back from the Prime Minister's office
Yes.
saying we want to make special representations about these projects.
It's not the
And
language they were using.
then sometimes that would be reflected in the next version of the spreadsheet, but other times it wouldn't be.
Yes.
Yes. Okay. Look, I just, in my final couple of minutes, going back to the Gaetjens report, and the difference, your evidence just previously with what the Prime Minister said. I mean, the Prime Minister quoted from the Gaetjens report and said, "I found no basis for the suggestion that political considerations were the primary determined factor." Would you agree with that conclusion of the Prime Minister?
As I said before, that's my understanding is the Prime Minister's quoting from a report that I haven't seen. I haven't seen the criteria that it was prepared under, the information that it's based upon. So I'm not going to make any comment on that because I'd be just speculating, and that's not what auditors do.
Okay.
It's not my role to speculate about things.
But just noting that your office had spent 9 months with 5 dedicated staff for the cost of over $600,000. So do you stand by the findings of your report, given those contrasting findings of the Gaetjens report?
Nothing's come to my attention which would lead me to change the report.
Thank you.
But we haven't done any audit work since that time because the audit's completed. So,
Am I 3 minutes?
No, you've still got a few minutes left.
Okay. All right. Okay. I just wanted to go to the 290 projects noted at paragraph 432. Let me go to it. Which I think when in the conversation with Senator Abetz before about the projects which were ineligible, that they were ineligible because they were either commenced or completed by the time the funding agreements were executed. You confirmed that that's the case?
Yes.
Yeah, so that was why they were ineligible.
That's what the terms of the funding agreements indicated.
Right, and so it wasn't that there was a big problem with their assessment, essentially that as time went on, they became ineligible.
They'd signed a funding agreement which included information which said the project was either underway or had been completed.
Right, thank you. I'll leave it there.
Thanks, Senator Ross. Senator
Thank you, Chair. Waiting in anticipation. Mr. Hare, could I ask about I'll just start with the 74 figure. So in the audit snapshot at the front of your report, you identify the 74 out of 100 as sort of a cut-off. Can you explain where that figure comes from?
So if you go to paragraph 3.12 of the report, Senator, so we've gone through and looked at the amount of funding available for each of the rounds, looked at the scores allocated and worked our way down, allocating the funding until it ran out for each round, which is we set through there. So the first round, if you funded the top 137 applications, you'd have used up all the money available with scores between 83 and 98. Then for the next round, when $30.3 million became available, you could have funded another 151 working down, so between 78 and 83. Then for the third round, with what became available then, which was $42.5 million, you could have funded another 165 working way down from 78 down to 74.
Right. So the 74 figure is your figure?
Yes.
Yep. So the 74 figure is not something that Sports Australia identified as some kind of cut-off or
That's correct.
legitimate... Right. So there was no notion that anything below or ranked below 74 should not receive funding from Sports Australia itself?
Sport Australia did not provide a recommendation that nothing below 74 should...
Yeah, a certain level or through... Sports Australia provided no threshold then, did they? Below which they thought funding shouldn't be
No,
provided.
they did provide advice at points in time as to saying we consider anything that scored below a certain level simply is not supportable for funding.
Right. Okay. But there's no magic in the 74 figure itself. It's just a pure arithmetic calculation.
The magic in it is that a normal process for decision making on grants where you've got a merit assessment is that you undertake assessments, you rank, and you fund according to rank.
Sure. So I want to come to that point now, though. So the 74 is your figure. In terms of the process that was done, first question of it, did Sports Australia provide their rationale for the scoring to the Minister or the Minister's office?
No, they did not.
Right. So all the Minister's office saw was a ranking with scores, like a scoreboard, basically.
With some information about each project, as I read out earlier, the applicant, the project title, a brief description of the project, how much money was being sought, the total value of the project, where it was located.
So, but they didn't have...
Did they have an assessment report column or something like that on
No,
their
they did
sheet?
not. They had the score was the only output of the assessment process they had. And
So
that's one of
all
the
they
points.
saw.
If you look at the recommendation, that's one of the recommendations we make is that it's often called a snapshot, if you like, a one-pager that goes with the assessment recommendations saying for each project, here's why we've scored it against each of the criteria like this in summary form.
Right.
How did they have the application?
So it was a score done by Sports Australia. There was a scoreboard provided, but no rationale for that. I now wanted to go on page 31, I think, of your report. You raised that there was an issue within Sports Australia around a conflict of interest, and I'm just getting that reference. Oh, here, sorry, I'm back to it. So you say in the footnote there, footnote 33, so I was getting confused, footnote 33 on page 31, Sports Australia's analysis was that this sport was, and I quote, one of the most organised sports to apply for the funding and has been particularly successful in round one. Which sport was that?
That was tennis.
Right. So it was tennis that was very organised apparently and was very successful. That footnote goes on to say that Sports Australia recorded that this was a result of the sport having a national strategic approach to funding opportunities. What does that mean? What does a national strategic approach mean?
Well, this is us quoting advice that Sport Australia recorded, so it's not our view, it's a question you need to ask of them.
Okay, so we'll have them in later to follow that up. So, but did you, apart from the quote there, did you have any more information before you about what that meant? When you say national strategic approach, did you know whether...
We examined the applications that related to that sport to see how they were assessed versus other applications and how they were approved for funding compared to other applications.
So did tennis as a group or as an organisation coordinate their applications in your assessment?
Applications were only eligible to be lodged by your local sporting group.
No, I know that, but were they... Obviously they were lodged by an individual sporting club or association, but was their coordination done behind the scenes before that lodgement by a coordinating body of some sort in the case
Senator,
of
we wouldn't know if that had happened.
So you didn't ask that question? You didn't ask that question?
Well, if I can, the projects we're talking about, there was a range of projects across the nation for a thing called Book a Court. So obviously there's that in the sense that there's very similar project in terms of the title, but also what they're looking to do is the same sort of thing repeatedly by many individual clubs.
So similar applications across tennis.
Yep, the amount would vary and so forth.
But you didn't ask, given that you found out from Sports Australia there was a national strategic approach in this sport, in tennis, you didn't then ask Sport Australia, well, what did that mean? Was there coordination?
No, we engaged with them in terms of what, if any, additional opportunities that sport was given.
Yes.
And we were satisfied that the things we were looking at was, if you like, information which should have remained confidential to the Commonwealth, such as drafts of the program guidelines, might have been what was being shared, but it wasn't at the stage of when decisions were being made and assessments undertaken.
Just stop here. You're saying so drafts of guidelines were provided to tennis officials, you're saying?
That was one of the concerns we had, yes.
Oh, sorry, that was a concern you had, but did it happen?
Yes, it did.
It did happen. So tennis, who was provided with those drafts of guidelines?
An employee within Tennis Australia.
Within Tennis Australia. So they got a rails run or a head start through this process.
Well, that was our concern.
No, sorry, I didn't ask you whether it was your concern, but you're saying they were provided information that other sports did not have.
Yes, well, that's what we say in the report, is that the risk here was it provided a competitive advantage.
Okay. So, So Sports Australia, or someone in Sports Australia, had provided a particular sport with an advantage over other organisations, and that, in your view, then, that must have potentially skewed the outcome of the ranking system, so to speak, by Sports Australia.
Well, no, so the concern here was this was in the design stage of the program. They weren't, in terms of what then follows that is once the design is finished, the guidelines are published, the assessments process.
That's right. But sorry, if they had some special information that allowed them to produce potentially high quality applications, and you basically imply that, or Sports Australia imply that, because they were very organised in their words and quoted in your report, surely then that gave them, that at least raised the question that the resulting scores were biased because of that early information provided?
No, because the advantage they gained, if you like, was a timing advantage. So they didn't get information which was above and beyond what ended up being in the program guidelines.
Okay,
but
they had more time. They had more time to put their applications in.
Senator,
I mean, they would have been competing. Sorry.
Just be careful to let him finish answer.
Okay, right. Well, I'm also very mindful, Chair, that we've got very limited time thanks to the skewed allocation of time by yourself on this committee. So I've got to go through quickly to Mr. Boyd. I'm sorry. So they had more. They're competing against mum and dad sporting associations who are trying to do these applications after they put their kids to bed or something, and you've got tennis out there who have a early start, got more information. Surely they are going to potentially do better because of that bias.
Well, and this is part of the process we work through is with Sport Australia raising the issue and then trying to understand what did Tennis Australia do with that information, and the assurances we were provided is that they worked with Tennis Australia to be assured themselves that the drafts of the guidelines didn't, because Tennis Australia isn't an eligible applicant, that those early drafts didn't go out to the constituency who would be preparing the applications, or the information in the early drafts of the guidelines didn't go out to the constituents who would be preparing the information, that it stayed within the national body.
Okay. So, in terms of results, how many projects involving tennis were funded?
We can take that on notice.
Okay, I'd be very interested in that number, and I'd also on notice then like to know other sports as well and their funding, particularly, and then also the proportion of success relative to applications.
It starts to become a challenge, Senator, in the sense that a lot of and part of this was in the design of the program. Right. It was meant to be looking to fund as far as possible infrastructure which would support multiple sports.
I get that. So there'll be some that are multiple sports.
Yep.
I get that. And then there'll be some devoted to individual sports. But it'd be very interesting, I think, to see those numbers compared to how many.
And I think Sport Australia is probably best, because that's sort of the data they
Okay, well, but I'll if you could take it on notice as well, because presumably.
Can I just clarify what we're taking on notice? You'd like us to.
Sorry.
You'd like us to give you information about the success of individual sports.
Yes. And
the success of multi-sport.
Yes.
But not including the individual sport, those which are in multi-sport.
That's right. Thank you. That's exactly the question now.
Could I just ask the Chair, and I take it from the time, like I'm not trying to steal your time, but those questions, wouldn't they be better directed at Sports Australia than the
sorry,
Audit
Senator,
Office?
I mean, I can ask questions.
I know.
If they don't have the information, if the Auditor General does not have the information, they can provide that. They can say that. They can say that. But I would have thought, given the issues raised here, that would have been some questions that they would have assessed and would probably have that information. But they've taken it on notice, so they'll come back to us. Now, I wanted to move on to your conclusions then. Going back to your conclusions, your conclusions based on the assessment process that was done in the Minister's office, that your conclusion that was in some sense inadequate was because it didn't meet the merit assessment done by Sports Australia. Is that correct?
I don't know what you mean by didn't meet.
Well, so I'll quote to you. On your audit snapshot, you say the successful applications were not those that had been assessed as the most meritorious in terms of the published program guidelines.
Yes, so set of published guidelines said this is how this grant program will be delivered and operated. Each eligible application will be assessed against 3 published merit assessment criteria and scored with the weightings disclosed. And what we're saying, and we set it out in the audit report, is
But I'm not sure how you could have reached that conclusion, with all respect, because we've established here tonight that the assessment process from Sports Australia was done by people that weren't formally trained, was often done, in 47% of cases, was done by just one assessor, with great deviance in results, sometimes as much as 30%. And we had an assessment process riddled with conflicts of interest. How could that in any way be a standard? That is assessed against the actual funding outcomes? How could you have drawn that conclusion?
As I said, Senator, the assessment process wasn't where the conflict of interest was involved. And as I also said earlier, that the merit assessment process by Sport Australia was the second stage in a 4-stage assessment process. It was followed by the assessment panel process, which brought in people outside Sport Australia, as well as the Deputy Chair of the Sport Australia Board, to go through all of this to satisfy themselves. And I said they made some changes. And that was then followed by the 4th stage of the assessment process, which is the Sport Australia Board looking at all of this and providing its endorsement or otherwise. And that was the process in the published guidelines that the Minister had approved to be conducted to inform her decision-making.
Well, with all respect, Mr Boyd, I mean, effectively what you're saying is if someone gets a 10-metre head start in a 100-metre sprint, the finish line's the same, so therefore there's no advantage. I mean, tennis organisations had a head start. They had a bias towards them through this process. So I don't quite understand how you could say that this was a meritorious process. It clearly wasn't.
But that's not what the evidence said, Senator. As I said, the disclosure of confidential information was from Sport Australia employee to the national body for one sport. Right. The question then was that national body is not an eligible applicant and did not submit applications for funding.
But they got an advantage against mum and dad organisations who didn't have that information. Now, I do want to move on.
Finish his answers.
But I'm sorry, given the limited time. I'm very sorry. I would not normally do this, but I've got now about 10 minutes, maybe less. So 5, right. So I've got to be very quick. I wanted to move on. In your opinion, and it seems to be the case in the conclusions, if the Minister made decisions based on the electoral status of a seat, whether Labor, Liberal, is there something incorrect about that or something not right about that?
What we're looking at is against we're assessing starting from the guidelines and the merit criteria which are set out in the guidelines. It's hard to reconcile geographic decision-making based upon any of the elements of the guidelines.
Right. So there's something inadequate about using electorate status as a decision-making.
No, there's nothing if it's within the framework that's being applied.
And put it in the guidelines.
Sure, but I mean, I just. Oh, sorry, Senator Roberts. I mean, I wonder here, because I've read a lot of your reports over the years, and they're very high quality. But I wonder the consistency across these reports and what precedent values are put on other reports. Because I'll take you to an audit report done in 2010-11, presumably on a previous Auditor General, but still holds weight. Audit report number 3, it was into the Regional and Local Community Infrastructure Program, which was administered by Minister Albanese at the time. And that report found on page 24 that projects located in electorates held by the Australian Labor Party and independent members were more successful at being awarded funding than those located in electorates by coalition parties. And that report was quite critical of that skew towards Labor-held seats. So given those previous findings, why wouldn't it be appropriate for a minister to look at the political spread of allocation of funding in response almost to previous finding of the Auditor-Generals? What is the problem with that?
Well, I think if you look at that audit report, Senator, you'll see that we criticised that approach then in the context of that program.
But you criticised it because it was too skewed towards ALP seats. So of course then subsequent ministers have to, on the basis of those findings, look at the political spread of allocation of funding. Wouldn't they have to?
No, we looked at that program in the context of, it was a global financial crisis stimulus program which had certain objectives set for it. We looked at what were the criteria set for that program to be delivered against, and there weren't any criteria. The criteria that were said to have been applied were recorded after the event, and we looked at whether there were assessments recorded against those criteria, and there weren't, so we couldn't satisfy ourselves as to how and to what extent those criteria were applied.
Well, we might take this up at other times because I don't have time, but I think there has to be a question of consistency here across your reports, because you have highlighted this, and I've got lots of other reams of quotes here and from similar and different audit reports where you've criticised the allocation of funding based on a skew towards a political party.
And there
so
are
I would have thought that then becomes an essential requirement for ministers subsequent to those reports to make sure that there is some...
And we've also published reports where there is a skew in the result, and we say that is reasonable given the criteria that are applied.
Right.
So we don't start from that basis. We start from the basis of the criteria that's being applied and work from there.
Now, so we have, earlier tonight we did establish though that the criteria and the guidelines did allow the minister to take into account other factors. That was
in
clear.
Assessing the criteria.
Yeah, clear. So I wanted to just draw out what weight then did you put on the evidence provided by the minister's office that they did have a criteria. It was allowed for under the guidelines. So what was the issue with that? Is there a potential issue with ministers applying their own assessment and differing from advice provided by an agency or a department?
Senator, what the guidelines say is in addition to the application and supporting material, other factors may be considered when deciding which projects to fund. But that's in deciding, applying the published merit criteria, not developing and applying unpublished merit criteria. We've seen this clause in plenty of grant program guidelines, including the RGIP program I mentioned, which we tabled a report on last year. And what that means is, in terms of ministers exercising their discretion to make a decision, it's still in the context of the published criteria, but you don't only have to consider when assessing people against that criteria the application supporting material. It can be other inputs, but in the framework of the published merit criteria. Not that you can apply unpublished merit criteria, which no one's been told about.
Yeah, look, I will, Senator Betts, did you want to dispute that too?
In addition to the application and supporting material, other factors may be considered when deciding which projects to fund. That doesn't limit it to the three criteria, does it?
What this talks about is, we've read to each other the same phrase.
Yeah, but where's limiting it to the three criteria?
Last question.
Not in it, is there?
Just got one
is
more
it?
topic.
Well, it is. If you actually go to the section around the merit criteria, it says eligible applications will be assessed against three selection criteria: community participation, community need, and project design and delivery. It doesn't say, and other criteria we have not yet told you.
Sorry, hang on, Mr. Boyd. No, this is an important point. This is a very important point. Sorry, okay, Chair, this is where you want to run it. You're going to shut down a question, you're going to shut down a line of questioning because it's uncomfortable to the Labor Party and the Greens Party. That's how you're running this show. Let's just put that on the record. You're shutting down questioning because you're uncomfortable with where that's going.
Senator Canavan, we've just had 20 minutes on you.
You did not apply a rigorous or a robust 20-minute rule of other senators. I'm fine with that. But let's just put on the record you've done that to the coalition because it's uncomfortable to your political purposes.
Exactly.
Wow. Senator Gallagher.
Thank you, Mr. Chair. Just in relation to a conversation we had in the private briefing, but just to get it on the record, of the 151 seats in the House of Representatives, how many of those were identified as marginal seats under the criteria used within the decision-making framework?
30, Senator.
30, that was for marginal, and then for targeted?
17, Senator.
Okay. How many seats weren't, didn't
Three,
have any
Senator.
application?
3.
3. And so the rest of that, once we do the maths quickly, would have fallen into the other criteria.
Yes.
And so in terms of the applications for, I think, approval, is it? Or applications that were approved of the 705, 32% fell within that marginal or targeted criteria.
So 32% of those, there was 705 applications identified as being in a targeted or marginal electorate. Of those, 228 were approved for funding across the 3 rounds, which is a 32.3% success rate. Of the other electorates, there were 1,236 applications in the population of those assessed as eligible, of which 456 were approved for funding at a success rate of 36.9%.
So the 32% was 408. Does that equal 400? Oh no, sorry.
So it's 228 out of 705.
Yeah, okay. I'll come back to that at another time when we have you back. In terms of your appearance today, Mr. Hare, were you approached by anyone in the government in relation to documents that relate to this audit?
No.
So you hadn't had any discussion, you or anyone else in your office, with senior public servants around your appearance today?
No. And I don't think I would.
No, I was just wanting to check. And on there's a footnote back on page 46, which relates footnote 56. It goes to the issue of the Minister's request for information from the 19th of September and receiving some information from Sports Australia on the 26th of September, which was being provided for the first time, I think, for the full list of 2,054 applications. The footnote says the Minister's Office had provided Sports Australia with a list obtained in relation to another grant program outlining the type of information it was seeking. Can you inform the committee what the another grant program was?
I can't recall the name. It was in the agriculture portfolio.
Could you take that on notice?
We can
please,
take that
for
on
the
notice.
Committee. And just in relation to, because I'm not sure we've been quite specific about the information that you're going to take on notice about documents and providing documents to the committee, because there are many versions of the spreadsheet, as you have explained to the committee. So I'm wondering if you could take on notice whether or not you can provide the full list of 2,054 applications that have been received. And also, I think the spreadsheet as it related to round 3 of the grants round is perhaps the 2 pieces of information that would assist the committee, accepting that you need to take advice on that.
Yes, Senator.
Thank you. Will you? What's your process? In terms of now making a decision about that, and you will. You've got the formal request from the committee. What's the next step?
When I get a formal request from the committee, I'll begin consideration of it, which in...
So you want something more formal than we've done? You've taken it on notice?
Yeah, okay.
Yeah.
I'll take it on notice. I'll give you a... what I'll do is look at the information you've requested. I'll go to the owner of the information and see whether they have any concerns or with respect to the publication, so the provision of the document to you, then I'll make a decision.
Okay. So it won't be just based on whether, because we know there will be concerns. Yeah.
You stopped me right on the knocker of 6.
It won't be just solely based on whether there's concerns raised. I mean, it's ultimately a decision for you under your Act?
Well, it's under the powers that the Senate has, largely, and but I will take into account, if there's a public interest claim, I'll take that quite seriously in my consideration. I don't believe it's my job to release things that executive government form a view that shouldn't be released. I'm not certain that's the role that the audit should take, because if we become the back door for the provision of information that the government doesn't want, it undermines our ability to do our work, I believe.
Yeah. Okay, fair enough. I mean, maybe perhaps, well, we'll get back to this another day, but I think also taking into consideration the interest of the Senate, the majority of the Senate, would be an important consideration for you as well.
Absolutely.
Thank you.
Thanks, Senator Gallagher. That concludes today's hearing. On behalf of the committee, thank you for your evidence today. If questions have been taken on notice, the committee will report to the Senate on 24 March 2020 and request that answers to questions on notice are provided to the committee secretariat by close of business 21 February 2020. Thank you to Broadcasting, Hansard and Secretariat staff for their assistance today. The committee stands adjourned.